Hi, I'm Jeff Myers with Fernandez. I'm an associate here at the law firm, and I'm here to talk to you briefly about the Oregon Trust Deed Act and the non-judicial foreclosure statutes. The non-judicial foreclosure statutes in Oregon were drafted in the late 50s and early 60s. Essentially, before the Oregon Trust Deed Act and the non-judicial foreclosure statutes, the only way that you could foreclose on someone's house was through a judicial process. In the late 50s and early 60s, the banks decided that they wanted a more efficient process that would allow them to avoid the cost and expense of doing things through the judicial process. So they had the legislature draft what is now known as ORS 86705 to ORS 86795. This is the statutory regime that governs how a non-judicial foreclosure is conducted. Under the case of Staffordshire versus Cal Western Reconveyance, the Oregon non-judicial foreclosure statutes are subject to strict compliance, which essentially means that it's not enough to substantially comply, you have to follow the letter of the law exactly. Now, there are a lot of requirements contained in the Oregon Trust Deed Act and the non-judicial foreclosure statutes. I do not have time to go through all of them, and you do not want me to go through all of them because it's really long and really boring. But essentially, the really critical points of this are contained in the prerequisites to the non-judicial foreclosure statutes that are contained in ORS 86735 and continue on through ORS 86740 to ORS 86755. This basically governs the process that the banks have to use in order to foreclose on your home. Under ORS 86735, in order to conduct a non-judicial foreclosure, the trustee has to meet 5 separate elements. They have to have recorded any assignments of the deed of trust by the trustee or the beneficiary. They have to have recorded any appointments of a successor trustee. There has to be a default on the part of the homeowner. They have to record a notice of default and election to sell in the county records. And they have to make sure that there is no separate lawsuit to collect on the debt. This basically means that they can't be simultaneously suing you for failure to pay and also foreclosing on their security interest in your home. Once they have complied with all of the requirements under ORS 86735, they can then move on to the step in 86740, which is where they will send you a notice of trustee's sale. This is a document that you will receive either via personal service, where someone will actually come to your door and hand it to you, or where they will post it on your property. This is actually what most people think of when they think of the foreclosure notice, because it's the one that is stapled or pasted to your door. The trustee's notice of sale will fix a sale date for your property. Between the time that the original notice is posted and the time that your property can actually be sold, there are a number of other steps that the trustee has to comply with. They have to publish the trustee's notice of sale 4 times in a magazine or newspaper in the county in which your property sits. They have to record affidavits of mailing. They have to provide notice of the sale to any people who are junior lien holders on your property. There are a bunch of steps that really aren't all that critical to your case, but the trustee nevertheless has to comply with them anyway. Now, essentially, when people come to us, most of them come to us because there are violations in the preconditions to a trustee's sale. That is to say that the trustee has failed to record all the assignments of the deed of trust, they haven't recorded an appointment of successor trustee, or there has been some issue with regard to the beneficiary, specifically an issue related to MERS. What this does is failure to comply with ORS 86735, at least in our view, is it invalidates the entire non-judicial foreclosure process. Many people are under the impression that once they receive a foreclosure notice or once the property has been sold, that they have no recourse, that they have to immediately leave. That's not the case. You do not have to leave your property until you have been served with an eviction and until they have prevailed in the eviction court. Under the case of Option 1 Mortgage versus Wall, you actually have the right to raise the issues that the foreclosure itself was wrongful, even up to the point of a counterclaim in an eviction proceeding. So even if you have been sued for an eviction, you can still raise these issues in the eviction proceeding. We obviously don't recommend that people do that, because by that point you really are under the gun and it's very important that you act immediately. But homeowners need to know that simply because they've received a foreclosure notice or simply because the property has been sold, that does not mean that their remedies are gone. We have helped many people who have come to us after their houses have been sold and after the banks have actually initiated eviction proceedings against them. So the upshot of all this is that there are many issues with regard to the non-judicial foreclosure process that the banks have done improperly. Your rights as a homeowner do not end when the foreclosure is completed. They do not even end when they have filed for an eviction against you.